here today for a virtual working session on docket number 0312, Message and Ordinance amending the City of Boston Code Ordinances Chapter 16 regarding targeted residential picketing, referred to the committee on March 2nd, 2022. This docket was sponsored by the mayor. In accordance with Chapter 22 of the Acts of 2022, modifying certain requirements of the open meeting law and relieving public bodies of certain requirements, including the requirement that relieving public bodies of certain requirements, including the requirement that public bodies conduct its meetings in a public place that is open and physically accessible to the public. The City Council will be conducting this working session remotely. This enables the City Council to carry out its responsibilities while ensuring public access to its deliberations through adequate alternative means. The public may watch this working session via live stream at www.boston.gov City Council TV and on Xfinity 8, RCN 82, Verizon 964. It will also be rebroadcasted at a later date. Written comments may be sent to the committee email at ccc.go@boston.gov and will be made a part of the record and available to all councilors. Since this is a working session, there will not be a public comment period. The purpose of this working session will be for councilors to review the specific language of the docket and to address issues and questions that arose from the hearing. This afternoon, I am joined by my council colleagues, Councilors Erin Murphy, Councilor Michael Flaherty, Councilor Kendra Lara, Councilor Tanya Fernandez-Anderson, Councilor Brian Worrell. We are also joined by members of the administration, Chief Nalor from the Office of Community Engagement, Attorney Adam Cedarbaum, Corporation Counsel from the Law Department, Attorney Rob Arcangeli, hopefully you correct that when I get to you, Assistant Corporation Counsel from the Law Department, and Superintendent Gerard Bailey from the Police Department's Bureau of Field Services. The committee held.
Actually, I just want to know that Councilor Mejia is here too.
And as Councilor Mejia has let you know, Councilor Mejia is here as well. The committee held a hearing on this matter on March 14th, 2022. This proposal would prohibit targeted residential picketing directed towards a particular residence during certain hours. All other ordinances and statutes would apply, including laws regarding excessive noise, disturbing the peace, and blocking streets and sidewalks. The provisions of this proposal would be enforced by the Boston Police Department, also known as BPD. The violators would be subject to fines of increasing amounts based upon the number of offenses. The committee discussed a letter from Corporation Counsel Adam Cedarbaum, who's here today, which stated that the proposed ordinance serves as a reasonable time, place, and manner restriction on speech that is content neutral and narrowly tailored to achieve a significant government interest of protecting the privacy of individuals in their homes while allowing for ample alternative channels of communication. The letter cited the Frisbee v. Schultz decision, where the United States Supreme Court upheld a similar town ordinance prohibiting picketing targeted at a particular residence. The committee discussed the legal standard of narrowly tailored to serve a significant governmental interest and discussed the balance of individuals' rights to protest and individuals' rights to privacy in their homes. Councilors also expressed concern with having enforcement by BPD and concerns about disproportionate impact on certain groups, unequal enforcement, and over-policing of Black and Brown communities. Councilors inquired about the enforcement and applicability of current ordinances regarding noise and disturbing the peace, and discussed including a sunset clause, which I, as the chair, actually oppose for legal purposes. But the committee heard public testimony at the hearing, which reflected both support of and opposition to the ordinance. Comments supporting the ordinance expressed support because of quality of life issues. Comments against the ordinance opposed it on the basis that it violates the freedom of speech rights and their right to protest. The following information was requested at the hearing: an explanation from BPD about why the existing noise ordinances have not been enforced, the total amounts spent on police details for the demonstrations at the mayor's residence, and at this point, mine and Ed Flynn's, though at the time it was the mayor's. The number of attorneys within the law department, their responsibilities and their salaries, as well as the amount of money spent on contracting outside legal counsel, and whether a stay-away order would be a more effective punitive measure rather than fines. Before I turn it over to my council colleagues, I'd like to read a letter of absence from Councilor Bach into the record. Dear Chair Arroyo, please excuse my absence from today's working session regarding targeted residential picketing. I believe the mayor's proposal is a reasonable limit in the tradition of narrowly tailored and evenly applied time, place, and manner restrictions that the Supreme Court has upheld as fully compatible with the First Amendment. Furthermore, I believe its limited penalties will ensure that, like our existing noise ordinance, its enforcement remains squarely in the civil rather than criminal realm. I want to reiterate my concern about any sunset provision, as I believe it would run afoul of the content neutral intent of the ordinance. I regret that a long scheduled absence from the city this afternoon prevents me from attending the session, but I will review the tapes and follow up with any questions or concerns. Thank you, Councilor Kenzie Bach. And now, by order of arrival, I will turn it over to my council colleagues for some brief opening remarks or any language changes they would like to see. I would also like to note that we've been joined by Councilor Rusi Louis-Jen and Council President Ed Flynn. I'm going to begin our speaking order in order of arrival. So that's Councilor Erin Murphy, followed by Councilor Michael Flaherty, followed by Councilor Lara. So Councilor Erin Murphy, the floor is yours.
Thank you. Thank you, Councilor Arroyo. And you did a great job summarizing our first session. So all those questions, I'm hoping we get answered in this meeting. And I do want to thank Brianna Malloy. You were at our meeting last time. So thank you for coming back and being there the first time, but also Adam Cedarbaum, Rob, and from the police department, Officer Bailey, thank you for being here. And I'm just looking forward to getting answers to the questions we have. And thank you very much.
Thank you, Councilor Murphy. Councilor Flaherty, the floor is yours.
Thank you, Mr. Chair. Just looking to hear from some folks at the administration or police around the noise ordinance and when it gets enforced, how it gets enforced. I think probably for the edification of our newer colleagues, maybe just a brief description of the current noise ordinance and how and what impact it has with respect to this particular ordinance. Thank you, Mr. Chair.
Thank you, Councilor Flaherty. Councilor Lara, followed by Councilor Fernandez-Anderson.
Thank you, Chair, for holding this working session. My typical script to follow during a hearing would be to thank everyone who's here. And so I will extend my gratitude for the administration and the folks from the Boston Police Department who are attending. And typically I would share my excitement to be in conversation with my colleagues about any specific issue, but the truth is that I'm not excited to be here. For me, this working session feels like a last-ditch attempt to make changes to what is a really short-sighted ordinance that, if passed, would no doubt disproportionately impact communities who use protest and direct action as a tactic to help make positive change in their communities. It's not lost on me the impact that these protests are having on Mayor Wu and most recently on Councilor Arroyo's family. But I think that we have an obvious problem that I don't think this is a solution to. And my hope is that we can make some changes that will lessen the harm that this ordinance could cause in the future. So I look forward to getting answers to some of our questions. Thank you.
Thank you, Councilor Lara. Councilor Fernandez-Anderson, the floor is yours. You'll be followed by Councilor Worrell.
Good afternoon, Mr. Chair. I'd like to thank everyone who's here, panelists and public or community members who are here to offer more. I just wanted to express my respect for my colleague, Councilor Lara, for taking her position. And this is an example, although she may need more time or feels we need more time, but it is an example of where we can disagree and work through it. And hopefully that we hear both sides of things and are able to work through this working session without rushing anything. I look forward to the panel's discussion and understanding to its full length of as far as like actions that have been taken and how our mayor have been protected along the lines of the protests. A lot of times I myself have driven past and witnessed or observed some of these picketing, and I have a lot of questions about how we're working to ensure that our mayor is protected when being stalked, when being harassed. So again, just want to understand both sides and want to be very firm in my position as well, all while respecting my colleagues in disagreement. Thank you.
Thank you, Councilor Anderson. Councilor Worrell, followed by Councilor Mejia.
Thank you, Chair, and thank you to all the panelists here. Just here to continue the conversation and to listen to the answers to the questions that were proposed in the last hearing. Thank you, and looking forward to the continued conversation.
Thank you, Councilor Worrell. Councilor Mejia, followed by Councilor Louis-Jen. Councilor Mejia, the floor is yours. Councilor Mejia, I'm not sure if there's a internet connection issue there.
Is that me, Councilor Arroyo?
No, there you go. Now we can hear you.
Yeah,
Floor is
I
yours.
don't know if you can hear me. I'm having audio issues, but just thank you for chairing. I'm here to listen and learn, and I do appreciate Councilor Lada's comments and share the same sentiments. Thank you.
Thank you, Councilor Mejia. Councilor Louis Jen, followed by President Ed Flynn.
Thank you, Chair, and thank you to members of the administration. Hello, can you hear me?
Yes, you're coming in clear.
Yeah, say thank you, Chair, and thank you to the members of administration for being here. In our last hearing order, a lot of questions came up, especially regarding language that currently exists in the draft ordinance about how, notwithstanding the ordinance, protesters would still be subject to all other ordinances and statutes, including but not limited to noise, excessive noise, disturbing the peace, and blocking of streets and sidewalks. And had a lot of questions regarding where does enforcement of those stand right now. Obviously, the protests have been quite a nuisance to public officials and to their neighbors. So here to get more insight from the administration on what does enforcement currently look like of the laws that we have on the books. Thank you.
Thank you, Councilor Louis Jen. Council President Ed Flynn, the floor is yours.
Thank you, Mr. Chair. It's good to be with my colleagues and with the administration team as well, in the Boston Police. I wanted to highlight the protesting out front of elected officials' homes, but especially outside of the home of the mayor. I think that's beyond protesting. I think it's certainly harassment, and in trying to intimidate an elected official to support a particular issue and not support a particular issue through harassment. And in this, as we come out of this pandemic, during this turmoil in our country, I think it's time we treat each other with some civility, with respect, with dignity. I think we can come to a compromise. I respect my colleagues' decision that may not agree with me, but I think there's an opportunity for us to come to some common ground and compromise on this. But I also know that these protests should not be used as an opportunity to intimidate an elected official, because what signal does that say to a young mother or a young father that want to someday run for public office, that this is the way we treat elected officials, by harassing them and harassing their children and neighbors, especially the neighbors. Many of them are elderly, many of them are persons with disabilities, veterans, young children. So we have to be more civil to each other and treat each other with more respect and dignity. Thank you, Councilor Arroyo. Thank you, Mr. Chair.
Thank you, Councilor Flynn. And I just want to do a quick, before I kick it over to the administration, I just want to summarize what is before us. The ordinance would limit the ability to engage in targeted picketing of a residence between 9 p.m. and 9 a.m. Targeted picketing means picketing, protesting, or demonstrating directed towards a specific residence. This ordinance would work in addition to existing laws around excessive noise, disturbing the peace, and blocking streets and sidewalks. Violation of the ordinance would result in a fine of $100 for a first offense, $200 for the second offense, and $300 for a third or next offense. The ordinance would be enforced by the Boston Police Department. And with that, I want to go to our administration. I don't know if you have an order that you would like to go in, but the floor is yours.
I can kick it off. Thank you, Chair Arroyo. Thank you to the entire City Council and other members of administration. I'm Brianna Malore, Chief of Community Engagement for the City of Boston for the Mayor's Office. I want to preface this by saying, and why I also kicked off, I cannot stay long because the ONS staff is having a training retreat today. But I wanted to make sure that I'm here for the short time because this is also a priority. we're joined here today to talk about a pressing concern that has truly been disrupting our neighborhoods and the lives of our residents. And I'm joined again by the other members of the administration from the legal department and the Boston Police Department to answer any further questions. As we learned in the initial hearing that I was able to attend and from the public testimony and the concerns of our neighbors, this ordinance is necessary and crucial to safeguard the quality of life of all of our constituents. I look forward to working collaboratively with the City Council and the members of the community to really support, to agree on supportive language that will protect the health and well-being of all of our residents against targeted picketing and while preserving the right to protest. Thank you.
Thank you, Chief Malloy.
I'll jump in next if that's okay. Thank you, Chair Arroyo, for having us here, and to all of the councilors who are here. I'm Adam Cedarbaum. I'm the Corporation Counsel. I appreciate you guys having us here to participate in this working session. Look forward to talking about the language or whatever is before us. And I want to pass it over to my colleague, Rob Arcangeli, who's joining me today, who's very familiar with these First Amendment issues as well.
Hi, Chair Arroyo, all the other councilors, good afternoon. My name is Robert Arcangeli. I am an Assistant Corporation Counsel in the City Law Department. In the session, I hope I am able to provide some further clarity on the legal analysis that was provided by Corporation Counsel in his letter on March 14th, and I hope I'm able to answer any questions that you may have to the extent that I'm able to.
Thank you, Attorney Arcangeli. And I believe that leaves you, Mr. Bailey.
Good afternoon, Councilor Royal. Good afternoon, everyone. My name is Gerard Bailey. I'm a superintendent with the Boston Police Department in charge of the Bureau of Field Services. I appreciate the invitation to participate in this important discussion. The Boston Police Department supports all efforts to keep our neighbors safe, comfortable places to live while preserving all citizens' right to peaceful protest. The officers of the Boston Police Department approach all complaints of excessive noise, regardless of whether they originate from a protest, a house party, or other gathering, with the intent to de-escalate, negotiate, and gain compliance. Citations and criminal summonses and arrests are only used as a last resort. Again, I look forward to this conversation, and thank you, Councilor Royal.
Thank you for being with us, Superintendent Bailey. And so with that, I'm going to just jump right into the actual ordinance itself. It's not very large, and so I will read it in full, and then we can go in order of folks who have edits or questions about this specific thing or any other questions, and we'll do that in order of arrival. So the ordinance begins with, it shall be unlawful for any person to engage in targeted residential picketing between the hours of 9 p.m. and 9 a.m. For the purpose of this section, targeted residential picketing means picketing, protesting, or demonstrating with or without signs that is specifically directed towards a particular residence or one or more occupants of the residence, and which takes place before or about the targeted residence. Those engaged in targeted residential picketing between the hours of 9 a.m. and 9 p.m. remain subject to all other ordinances and statutes, including but not limited to laws concerning excessive noise, disturbing the peace, and blocking of the streets and sidewalks. Any violation of this section shall be punishable by a fine of $100 for the first offense, $200 for the second offense, and $300 for any third and subsequent offense. And this section shall be enforced by the Boston Police Department. That is all of the language. And so with that, I'm happy to go in order of arrival or in order of hands. I know Councilor Flaherty and Councilor Lara have questions about language. I'm not sure if other colleagues do, but I will do this in order of arrival. If you don't have a question at this time, you can simply just say, next time around, I'll come back around, or we can try and make this as organic as possible. But Councilor Murphy, that would place you first.
Thank you. Quick question, it may come out in different questions that get answered, but if this isn't specifically protesting, like how has this behavior crossed the line? And is there any behavior that is already happening at the house of the mayor that could be offensible? So maybe Officer Bailey, like, is there any behavior that we could already be arresting or, giving fines to the protesters now?
Councilor Murphy, there has been no probable cause to make an arrest at the House. We use de-escalation, diversion, negotiated skills to achieve the best outcomes in difficult situations every day out there. We just started to, we contacted West Roxbury Court about the noise violations, and that is something that we set up on Monday, and we have notified protesters about the noise ordinance, and we can set up hearings out there in conjunction with West Roxbury District Court, which we started on Monday. However, we had not to issue any citations this past week as a result of that, Councilor Murphy.
Okay, thank you.
Thank you, Councilor Murphy. Councilor Flaherty.
Thank you, Mr. Chair. And on sort of on the same lines as Councilor Murphy's inquiry, there's been a lot of discussion regarding the noise ordinance, particularly from the hearing, and why the ordinance has or has not been enforced. Can someone, maybe it's Superintendent Bailey, can someone explain the decimals that would merit enforcement in the zoning area? And there are varying zoning areas across the city, and whether it's their sub-districts, et cetera, would those decibels change? That's the first one. And then the second piece is, does BPD and or ISD, do they keep a record of the noise complaints and noise violations and or any other sort of clear data that gives us a sense as to how many noise violation calls or requests we get and that you guys need to enforce each year? Thank you.
Councilor Flaherty, the decibels at 7 a.m. is 70 decibels, which is not much more than general conversation. As far as keeping track of noise violations, 911 calls, they are tracked, I believe, Councilor Flaherty. But as far as a protest, coming from a protest, I don't know if we track noise violations coming from a protest or a similar event, but clearly for like a loud party disturbance type of thing, I believe we do track them. But as far as I have, at my knowledge, there's been no one cited for noise violation at any First Amendment protected event protest in 2021.
Thank you, Superintendent Bailey.
Thank you,
Thank
Councilor.
And is that it, Councilor Flaherty? I'm happy to go to the next question.
Yes, yeah, no, I'll stick around for further rounds. But those are the questions that jumped out on the decimals and the noise violations and whether or not we're tracking them and enforcing.
Thank you, Councilor Flaherty. Councilor Lara, the floor is yours.
Thank you, Chair. And do you want us to just ask one question and we'll go around, or?
No, literally, if you have questions or anything that you want to engage right now in terms of the language or any of that, this time's yours to do that.
Okay, thank you. So some of my colleagues have already made comments about these not being protests, but in fact being targeted harassment. And we do have law in the state against targeted harassment that, at least to me, when I read it, is very obvious that is what's happening at the mayor's house and at everybody else's house. And so, and just for the record, I'll read what the state law says. It says that whoever willfully and maliciously engages in a knowing pattern of conduct or series of acts over a period of time directed at a specific person, which seriously alarms the person and would cause a reasonable person to suffer substantial emotional distress, shall be guilty of the crime of criminal harassment. And so are there any city-specific ordinances or laws regarding harassment that read differently than this? And why are we not having a conversation about criminal harassment if there isn't? And that could be a question for Adam and Rob or for Officer Bailey.
I can start with just city laws. I am not aware of any city harassment law of this nature that is different than this. The city does not generally make criminal laws, though.
And so, so it seems that we have a law against harassment that is being violated. Is there a reason why this has not been enforced? It seems like there's a criminal law against harassment.
Is that question for Superintendent Bailey?
It could be for Superintendent Bailey, yes.
You mind trying to take a stab at that, Superintendent Bailey?
Yeah, Councilor Royal. Harassment, again, if it's probable cause that we can, that shows that willfully violating and targeting harassment. Again, I believe it's a series of 3 different events in order to constitute the harassment. But again, our stand on any type of protest, particularly with First Amendment issues, ma'am. We've had a long history of using discretion and de-escalation to manage situations in all our Boston neighborhoods, including protests and demonstrations. So the preferred response, again, would be de-escalation, diversion, negotiating skills to achieve the best possible outcome in these situations.
Thank you. And I appreciate that. And I think that that approach should be maintained. And I think that 10 weeks of what we've seen of singing Happy Birthday Hitler outside of the mayor's house and following her while she's walking her kids to school and showing up at people's homes, it goes beyond what you're referencing in terms of the First Amendment and protest, right? So I think that that is the approach that we should take. And I want to maintain that approach in terms of de-escalation. But given how well documented, one, the extent of the harassment and the impact of the harassment, I think that we're beyond we've moved beyond the First Amendment and protest at this point. And so I would love to hear what, in the sense you were saying probable cause, you know, following the mayor while she's walking her kids to school, superimposing her face over the, you know, the North Korean president, yelling racist, sexist remarks at her outside of her home. There's veterans, children, and elderly people who live next to the mayor, all of which fall under this definition of criminal harassment and have happened more than 3 times at this point. And so what for the Boston Police Department would probable cause look like outside of what we already have?
Well, the incident you're referring to, ma'am, I believe is the mayor was walking their children to school, and they followed down the street. There was approximately 5 to 6 officers in between the two parties, the mayor and the protesters. And again, her safety is paramount to us and her children, as well as the neighbors. And we had her protected that day, ma'am.
Thank you. I really appreciate you affirming that the mayor was protected and being cared for, and the individual still took the action. And so, you know, given what we're having here, we already have ordinances against excessive noise, disturbing the peace, blocking roads and sidewalks, all of which we have talked about here. They've also violated all of those ordinances. It's very clear that the language of the state law shows that they are guilty of criminal harassment, or at least could be brought in for criminal harassment. And so how have any of these been enforced in the past 10 weeks, or do you know how many citations have been handed down? Because at this point, you know, the mayor is protected, but the mayor is one person. And these folks are having an impact on, like Chief Milor said, on the community. And they're not just harassing the mayor. So what has been the accountability measure and the enforcement measure for the people? Even if the mayor is safe, they're still taking the action.
Again, ma'am, the mayor's safety, her children are paramount to us. And if the mayor, I believe, you know, if this ordinance is, initiated for her safety or her house, the targeting, if the mayor chose to file her harassment order, the mayor could do that. And we could cite the 3 incidents that she felt that she was threatened. And I believe her attorneys could apply for a harassment order. So the city attorneys might want to answer that. I'm not sure.
Can I just jump in there too, Superintendent Bailey? Could her neighbor or neighbors file such a harassment order, since they are also subject to what I would call sort of an emotional, in terms of, we've talked about physical safety. I think when you're talking about young children being screamed at and yelled at and having their parents screamed at and yelled at on the way to school, there is certainly an emotional and mental attack that is happening there. Whether or not they are physically being harmed, they are certainly emotionally being harmed. And I think the question that I certainly have had watching these videos is, I appreciate and frankly, I'm proud that we are attempting to de-escalate and divert. That is work that I commend. But I also think there comes a time where we see lines crossed, and for me, children fit that line pretty astutely. And so when we're talking about a harassment order being the mayor's job to bring one forward for you to enforce it, could a neighbor bring one forward as well, since they are also sort of being disturbed in this way? They're being having their peace disrupted and being targeted as a neighborhood. To your knowledge, would they be able to file for a harassment order even though the direct target of their harassment is the mayor, because they are receiving sort of the residual harm?
Councilor Royal, I agree with you about the children. That's taking it a step too far, with the children. I agree with you. As far as the neighbor filing harassment, in this ordinance that I'm reading, it's targeting. So I don't know if they're actually targeting them. Councilor Royal, would they able to do that? But I'm sure one of the attorneys from the city might be able to answer that. But again, they're targeting your house, but I live beside you. Could I file a harassment order? I'm not sure if they're not harassing me per se. Maybe one of the attorneys could answer that, Councilor Royal.
Thank you. And that's kind of my concern. I'm not sure they can, but if Attorney Cedarbaum, Corporate Counsel Cedarbaum, and I also just want to note we've been joined by Councilor Lydia Edwards as well. But Attorney Cedarbaum, if you can sort of speak to that.
Thanks. I actually might let Rob correct me here, but essentially, although I think these are really good questions, these are in the context of criminal law affecting an individual or an individual seeking a civil order. Those are not sort of municipal functions. So the law department could not sort of represent or advise, for example, the neighbors on their ability to take advantage of those laws.
And I'm going to go back to Councilor Lara. I think we want to make sure that other folks get a chance to participate. So we'll do a second round, obviously. But if you have any other questions along this line of questioning, I'd like you to be able to get them out now.
No, just confirming with everyone that, one, given the letter of the ordinances that we currently have and the state laws, that these folks are violating our ordinances, probably guilty of criminal harassment based on what they've been doing at the mayor's house for the past 10 weeks. And that there has been, just confirming that there has been little to no enforcement of this.
Thank you,
There have not
Councilor.
been citations handed down or anything of that. So just confirming that. And then my other questions I can ask in the second round are for Adam and Rob.
Thank you. And we'll certainly come back to them for language as well on when we get to the ordinance part of this. I want to give Councilor Edwards, who didn't get a chance to give an opening, and then I'll go back to the line of questioning, and you'll be added to as well, Councilor Edwards, if you're ready now. Okay, we'll go to who's next in line. Councilor Fernandez-Anderson.
Thank you. I guess I just want to, understand, we're here essentially to talk about picketing, but then we're also making it clear that this is not just a protest, it's turned into harassment. So that we're clear that if this is not violating the First Amendment rights, then we're talking about harassment. And I think that will guide the direction in which we go in terms of the purpose for this hearing. If we're talking about harassment, then we're talking about harassment. And then if we need to amend something in order to address that, then that's what we're here to do. And then that we're very clear that I guess just for the superintendent, I guess, I understand in terms of, processes, in terms of, if the mayor feels harassed, then she needs to file. And then there's also nuance and sort of, I guess, energies and relationships and respect that goes into, when you're working with the mayor or when there's detail assigned to the mayor, that there are levels of this thing, right? Where sometimes we can just do a little bit more so that people can feel protected and so that the people doing the harassing understand that there are boundaries set. And I just want to put that out there because we're talking about a woman taking her children to school. We're talking about a woman of color taking her children to school. And then we're talking about, the first elected woman of color mayor taking her children to school that people disagree with on certain positions. So there's a lot going on here, and we need to be very critical, very intentional in how we protect this woman. And so there's more than just, okay, if she feels this way, she should file, but also that there was some level of communication and tone set for the people assigned to detail that she needs to feel protected, and the protesters need to understand that there are these boundaries that they cannot cross. And I can, in terms of just human dynamics, it's starting to feel that, and I'm starting to understand that that's obviously not clear for the protesters or for our mayor. If she's traumatized to this magnitude, where when there are details assigned to her and she does not feel that she's protected or that the harassers don't understand that there's clear boundaries, then I guess I'm having a hard time understanding that. And I just want to bring that out because there are human dynamics at play that we don't necessarily talk about when we're talking about breaking laws, right? And so what about that? What about all of these nuances that I think we can build relationship with, with each other and ensure that we're communicating that clearly to people that feel they can harass a woman taking her children to school.
Councilor Anderson, who was that question for?
I think for the superintendent, I want to communicate this to the superintendent or to the Boston Police Department. If you can imagine that this was your mother or sister or wife or daughter, I'm just trying to see if people can understand that there's more than just, different steps that we can take in order for us not to be harassed or feel harassed or follow the law. I think there are, again, relationships. How do we have communications, or do we need to sit down with the Boston Police Department? How are we actually executing that? And the things that we are not necessarily talking about right now, that I can imagine if I was in her shoes, I would be feeling, if I don't feel protected, or if that continues, or if people don't understand clearly that there's a boundary, how those things are not being communicated.
Thank you, Councilor Anderson. I just do want to note, we've spent some time here discussing, I think rightfully so, Mayor Wu and what is happening at her home, but this is not isolated to her home and her neighbors. This has happened to now Councilor Flynn, who does not have the luxury of a detail, to my own mother, who has never held elected office and certainly does not have the luxury of a detail, and to myself. I think it's important to just note that this isn't just targeted for the mayor or for her family, but also for the families of other elected officials, for folks who live near those elected officials, for the families of those other elected officials. And so it is a bigger issue than just the mayor, though I do want to also be clear that I believe the mayor has now gone on 10 weeks of this straight thereabouts. And so I don't know if there's a answer to what was presented there, Superintendent Bailey, in terms of just the understanding of, I think the frustration, frankly, that folks have at feeling as though at this point they've crossed the line in terms of what we would call protest to harassment, and the feeling that there has not been any sort of noise ordinance violation. Even though I represent the area, I can tell you I've had residents talk to me about having the noise decibels and measuring them and seeing where the noise decibels are. And I understand that, to be clear, Superintendent Bailey, it sounds like BPD has a sort of a policy of noise and protest in which they've never really enforced noise ordinances. But I do think when we're getting to a point where it's, happy birthday Hitler and you're evil and the things that we're talking about being yelled out in residential neighborhoods, that folks have a right to peace in those neighborhoods. And so I guess the question is, why has BPD decided not to write or cite noise ordinances here? I know there was drumming at my mother's home. I know that when we get to my district where Mayor Wu lives, there's been sort of banging of noise, and lately there's been an attempt to try and keep that from happening. I know in my home there were whistles and banging, and so the question is, what has led to, for instance, the enforcement of a noise ordinance for a party, but not the enforcement of a noise ordinance for essentially a protest in front of someone's home at 7 a.m? That's a question for you, Superintendent Bailey. What are the protocols being sort of followed? There are unspoken rules here. Are there rules that we should know about in terms of how noise ordinances are handled at BPD? Are you there, Superintendent Bailey?
I'm sorry, Councilor Roy.
No, are you muted?
I had you. Can you hear me now?
Yeah,
Sorry
no problem.
about that, sir.
Yeah, there you go.
So I'll try to answer a few of those questions. One, as far as criminal harassment, I'm not leaving it up to the mayor to do that. If we have probable cause to arrest someone on criminal harassment, we would. As far as, if it was my mother is deceased. But I have empathy and sympathy for the mayor and what's going on out there for her family, and her neighbors. And your mother as well, Councilor Royal. I know they went to Ed Flynn's house. They've been at Lydia Edwards' house in the past during the police budget, Governor Baker's house, and all this. But I have empathy and sympathy for everyone involved with people in front of someone's house. As far as the criminal harassment, we would arrest if we had probable cause to do that. As far as the noise, it's not an informal, it's not a rule, Councilor Arroyo. Like I said to you earlier, the First Amendment, the protest, it's a very delicate balance. We're trying to weigh the protesters' First Amendment rights and the people they're protesting against. As far as the noise at any type of protest, any protected First Amendment protected event, whether it's a protest or march in front of the mayor's house, we haven't cited. Like I said, Captain Greeley is out in E5 out in West Roxbury. He coordinated with West Roxbury Court, and as of Monday, they're going to do noise ordinances. There was people out there, I believe, on Thursday or Wednesday, excuse me, and there was a sergeant out there, explained it, the noise ordinance to them, and they didn't have any noise devices with them. Again, our position has been, and it's been like that for a number of years, is de-escalation, diversion, negotiation for people to comply. People haven't been blocking sidewalks. People have been moving back. Again, the noise violation, again, is going to be in effect. It is in effect. And there hasn't been any noise violations or citations for that matter for any event, First Amendment event leading up to today.
Superintendent Bailey, my highest regard to your beloved mother. I think my question when I posed it was general, so I hope we can continue to communicate in a way that we continue to receive each other respectfully. Again, my highest regards to your beloved mother.
Thank you, Councilor Anderson. Thank you as well, Superintendent Bailey, for your answer. I'm going to try and keep going in order of arrival for questions. Councilor Mejia, followed by Councilor Louis Jen, if you have any questions specifically or any edits.
Yeah, no, I'm so glad that we're talking about what I always say is the elephant in the room. Like, we're really talking about the fact of the matter is that there is a level of disregard for the harassment that has been going on for 10 weeks, right? In terms of what this conversation is, and really about the accountability in terms of who and what we're choosing to uphold, right? And the fact that we're now thinking about upholding the noise ordinance is alarming to me, which I think is we should have nipped that in the bud when it first started, right? So I think that we've allowed this to go on to this point, which is why we find ourselves having this conversation. But I do think that there's an opportunity for us to really also look at, and while I appreciate Adam's comments in terms of not being able to provide residents any legal counsel, and I totally understand that, but we also have to be super mindful of the unintended consequence and the residual trauma and the vicarious trauma that the neighbors are experiencing, right? So if we are seriously understanding that we represent 700,000 constituents, their mental and social and emotional well-being should be something that the city is also held accountable to, because it's not just about Mayor Wu, as Councilor Arroyo stated, and other elected officials. It's really the surrounding neighbors. And I think that we have a responsibility and an opportunity to really lean into this conversation. And I'm just incredibly curious about the who and what we're choosing to uphold, because if it's targeted harassment, it's going beyond targeted picketing. I'm curious as to why the BPD did not lean into not so much arresting and citations. Like, why not? I need to hear that. I need to know why not.
I think that's again a question for you, Superintendent Bailey, and I think it seems like most of these questions are for you today. So I appreciate you fielding them.
No problem, Councilor Roy. Again, our position on this First Amendment issue has been discretion, de-escalation, and having people comply. As far as I know, the other councilor mentioned the mayor's safety. I've talked to the mayor personally. Chief Long talks to the mayor. We've talked to her dignitary protection group. We've put additional officers out there. And again, we're trying to just de-escalate the situation and make her feel safe at the same time. But we are putting a number of resources out there in order to protect her and her neighbors and her family.
Right. So I thank you for that, Sergeant. But I think it goes beyond the protections. My question is specifically about why we are allowing bad behavior to continue. And, you know, why did it take us 10 weeks to get to this point right now?
I don't know why this ordinance was just written now, ma'am. But
no, I'm asking about in terms of, I'm talking specifically about why weren't citations around the noise ordinance, knowing that there was the issue of quality of life, and that already this ordinance exists in the city. Why weren't we adhering to it? And I'm also curious if we are about making sure that permissible cause or whatever it was that you mentioned earlier. I'm just a little bit confused as to if we know that this is being targeted and it's targeted harassment, why wasn't it addressed? Because I do believe that to Councilor Tanya Fernandez Anderson's point in terms of just human dynamics is that if you can get away with something, you're going to. And they had been given permission, if you will, for the last 10 weeks to get away with it for that long. So I'm just curious as to why weren't we upholding existing ordinances to protect the mayor?
We have been protecting the mayor.
No.
Sorry.
I mean, I'm saying in terms of why, I just want to know for 10 weeks, we've allowed folks, right, to violate the noise ordinance that's in place. For 10 weeks, right, we've allowed folks to targeted harassment. So I'm curious what level of communication and protocols were put in place to help address the bad behavior of the protesters.
Yeah, I think the question there as well, Superintendent Bailey, is you mentioned that I think it was this week you set up something with West Roxbury Court for noise ordinances. I think the question here is why did it take until this week to do that?
I thank you, Councilor Royal. As far as what steps we have taken, like I said earlier, we have put additional officers out there from various different districts out at the mayor's house when she's leaving the house. We have used de-escalation tactics out there. We have spoken to the mayor and spoken to her dignitary protection. We actually put that ordinance in effect. It doesn't happen every day, Councilor Mejia. The people don't show up there every day. I know it's been going on for 10 weeks. In the past 2 weeks, I think it's only been 3 times. 1 or 2 people have been out there. They're not always playing drums. They're not always whistling. Again, there was a sergeant out there on Thursday, told them about the noise ordinance, and they didn't use any devices. So we decided to do it on Monday, and after the captain arranged it with West Roxbury Court, that was put in effect. As far as the harassment, that is being talked about in this ordinance. And again, if this ordinance passes, we'll use this as another tool in our toolbox, and we'll use a discretion to, in de-escalation in this as well.
Okay, thank you for that, Sergeant. And I know we keep going back to the same questions, and we really do appreciate your patience in answering them, and they come in all different forms, so appreciate that. This question is specifically for Rob or Adam, right? The City Council, we see ourselves as the financial stewards of the city, and I know you guys are always yielding lawsuits from all different spaces and places. And so I'm curious, from a financial impact, especially on the social and emotional and the traumatic impact that this is having on the surrounding neighbors, what protocols, policies, and procedures, or even you're thinking about that this could have on the city if people, begin to say that now their well-being is not being protected by the city. Is there a way where we can potentially end up being sued by those neighbors, and will that move us to act differently? And Ricardo, Councilor Arroyo is a great translator, so he usually understands what I'm trying to get at. So if there is any need for translation from a legal standpoint, I
think Corporation Counsel Cedarbaum gets it. I think what you're asking is a very reasonable question, which is the city liable for emotional infliction or any other issue that may be coming as a part of this these sustained protests?
Yeah, I think I'm happy to take that. Councilor Mejia, it is and this is sort of a new question. We haven't dug way into this, but it is my initial assessment that the primary cost to our community here, that it is real, and I think that what you're talking about is a real cost to our community, to people's quality of life. I do not see the primary potential cost as being legal liability to the city. But I do not think that just because I don't see an immediate path to sort of legal monetary liability, that it doesn't mean that the sort of social and psychic and quality of life costs that you identified aren't real, and that that's not, that is the important work of, I think, our city and this body, in this government. And just because I don't see a immediate path that's obvious to me for there being sort of legal liability from the city's coffers to, for example, a neighbor who's been really deeply impacted by this, doesn't mean that that's not still a very real concern that we as a community can and should be thinking about.
Thank you for that, Adam. And I also just want to underscore that it's not just the social and emotional, it could also be the financial well-being of someone if you have to go to work. And if you are a remote worker, that will impact your ability to also function. So I just kind of want to name that. And although this might not be the topic of conversation in terms of the unintended consequences, that it goes beyond the targeted people, but just how it spills over to the larger community. And I just kind of want to uplift that here in this conversation. Thank you.
Thank you, Councilor Mejia. And so on this first pass through, we're going to do these, we'll continue the questions. On the second pass through, it'll be a show of hands and an order of hands for language, if folks have language changes they'd like to make. So in order, so folks can be prepared, it's going to be Councilor Louis Jen, followed by Council President Flynn, followed by Councilor Edwards. So Councilor Louis Jen, the floor is yours.
Thank you so much, Chair, and thank you to everyone, again, from the administration for being here to answer questions. I think it was Superintendent Bailey, and you may have already answered this, but just to ask to be very clear, and this is going to probably require input from the law department, but there's no legal difference between the source of the noise in terms of enforcement of the unreasonable noise ordinance under the city, right? I just want to clarify that there's no legal difference between the source of the noise in terms of enforcement under city law.
I don't think I understand the question, ma'am. I apologize.
So whether the source of the noise is First Amendment protest or construction or someone singing loudly, it's a matter of decibels, right? And not necessarily the content of what's happening, so that there's no, it's just about the noise and not necessarily what the source of the noise is. That there's no difference in enforcement or provision or a difference in the content of the source of the noise under city law that would change enforcement.
I believe you're correct, ma'am.
And can you just expound on that, Adam and Rob?
Absolutely, Councillor. Well, I can say sort of simply that your description of our various noise ordinances, and there's probably a few that are relevant, but they're all sort of in Chapter 16, Section 26 of the code. Yep. I would say that description is absolutely accurate. It always describes it in terms of amount of noise or decibels. It does not, with a few, there are some specific sections that sort of talk about specific types of amplification devices and things like that. However, there are two sort of more general sections that talk about sort of noise in the abstract, basically just as a volume and as something that is causing a certain amount of impact and that is a certain volume measured at a lot line.
And so are there actions in the last 10 weeks that would have amounted to a violation of Chapter 16-26 based on the actions of those outside of the mayor's home and other people's home?
I don't think a law department can answer that. We're not really actually sort of in command of all the facts or whatever of what's happening on the street or the specific volume or anything. So we can absolutely confirm that you are looking at the same place in the city of Boston code that we would look.
The unreasonable noise, yeah.
And I think that question was probably better handled by Superintendent Bailey, who probably would be able to answer that exact question, Councilor Louis Jen. So Superintendent Bailey, if you could just answer that question that was posed by Councilor Louis Jen.
On particular days, ma'am, they've asked to put whistles away, drums and things of that nature. Again, 70 decibels is not much more than a little louder than a conversation, ma'am. So without measuring it personally out there, I could only speculate, but there have been other noise devices out there. And if it's 70 decibels is not much over a normal conversation, I would say yes.
Yeah, and yeah, I mean, I speak loudly and I often violate that. I could easily violate that. So I can see how people together that are congregating are habitually can be violating that decibel requirement. And I was wondering if you could give us example of any citations or citations made in the last 10 weeks or that you're familiar with that have violated this unreasonable noise provision, not connected to the mayor's home.
Not connected to the mayor's home, ma'am.
Yeah.
I have no knowledge. And since last year, up until this year, I have no personal knowledge of any person being cited for a noise violation at any type of First Amendment protected event, whether it's a protest at the mayor's house, a protest, a march somewhere else, ma'am. I personally cannot think of one person that was cited for a noise violation.
Yeah, I appreciate that answer, Superintendent, but you see how that connects to the first question, in that if the unreasonable noise issue is unrelated to the type, is unrelated to whether it's a First Amendment protest or a party, right? I'm actually talking about more generally citations for violations of the unreasonable noise ordinance, not necessarily related to the First Amendment.
Has anyone ever been cited for a noise violation, ma'am, in the past year?
In the past 10 weeks or year?
I believe, ma'am, there's been citations for different venues, bars and things of that nature. I believe there's been noise citations for that through the liquor license and that authority, ma'am.
I'd be curious, I'd be interested in getting sort of from your department citations issued for noise violations, both in the last 10 weeks and also the last year. If we could get that information, that would be helpful.
No problem, ma'am.
And then, so then I think this is a more targeted question to you as well, because, even how you answer that question in terms of no citations related to First Amendment, it seems as though, although not written anywhere or required, that there is differential treatment in terms of the source of the noise by your department. So we tend to offer more leniency to when someone is, when the source of the noise is related to someone's First Amendment right. Is that right? Is that correct from your department?
We do use discretion at every situation we go to, ma'am, but we get calls for loud parties, protests, and I don't think any of them have been cited for a noise violation.
Okay, I think that's why that data would be helpful. But just so that I'm clear, is that your department treats the noise generated from a protest or some other First Amendment activity differently than noise generated in other scenarios? That's what I thought I heard you saying in the beginning of this session.
I don't think there's been any noise citations at any protest or event. Like I said, as far as if we wrote any, ma'am, and not to treat anything differently, we don't treat anything differently. But the only time I think there has been some written, it has something to do with a bar or over loud noise at 2 or 1 o'clock in the morning, something like that.
Okay, and then what about for disturbing the peace? Have there been any, again, unrelated to the mayor's home, have there been any citations in the last 10 weeks or the last year that you can think of issued by the department for disturbing the peace?
I'd have to look, ma'am, and we'll get you that information, but I think majority of it was probably with an additional violation as well, but I'd have to check on that and get it to you.
I'd really appreciate that data. Thank you. And then just lastly, I'm just, trying to also make sure that we are being very intentional about the language that is currently in the ordinance. The third question is examples of recent citations or arrests made for blocking sidewalks and streets, also within the similar timeframes, just so that we can offer, so that we can have a good comparative lens.
I will look for you, ma'am. Again, personally, I do not have any knowledge of anyone being cited, arrested for blocking a sidewalk. But again, I'll get you that information for the last 10 weeks.
Thank you. I appreciate that, Superintendent.
You're welcome, ma'am.
And I think 10 weeks for the purpose of this conversation, I think is helpful because for that comparative lens, but potentially there's nothing in the last 10 weeks. So if you could also extend the request back for a year, that would be helpful too. So both 10 weeks and a year, because again, this shouldn't be about any single individual. This is about, protests and actions in general. And so to ensure that that is the case, I think a wider lens here would be helpful. Thank you.
No problem, ma'am.
Thank you, Councilor Louis-Jen. Councilor Flynn, followed by Councilor Edwards.
Thank you, Councilor Arroyo. Thank you, Mr. Chair. Let me just say, I had the opportunity to work closely with the Superintendent Bailey for many years, and outstanding police officer. So thank you, Superintendent, for the work you're doing in our city. My comment and question is, to me, I've been picketed also and harassed by protesters. Had the opportunity to serve 24 years in the Navy, served in Operation Enduring Freedom, and had someone call me a traitor, screaming at me, calling me a traitor, and other nasty comments. But we can talk about these legal issues all day long, and listen to lawyers and see what's legal and what's not, and but let me be clear. This is intentional harassment against the mayor. It's trying to intimidate the mayor. It's trying to intimidate a woman of color to change her position, to do something. And that's all this is. It's intentional. It's trying to hurt her and her family and her neighbors. And we can't lose focus on that this vindictiveness of harassment. I don't even call it protesting. This is harassment, is intentional, and it's meant to cause pain and cause harm to the mayor and to her family. And that's the troubling part is these protesters want to hurt her personally, and they want to hurt her family. And the protesters don't care about the neighbors. Many of them are seniors. One of the gentlemen is a World War II veteran. Someone else supported various military exercises overseas. There's little children. So these protesters don't care about anybody at all but themselves. And they intentionally want to hurt the mayor. So I'm frustrated with this conversation. I'm gonna be honest. I'm frustrated because I don't want us to lose sight of the fact that this is intentional, and it's trying to cause pain and hurt in a woman of color. That's our mayor that represents the people of Boston. So that's how I feel about this issue, and just want to say thank you, Mr. Chair, for your important work on this. I respect the work you're doing. Let me just ask one question, and this is to Adam. And Adam, if you could give me a direct answer. You've watched the videos like I've watched the videos. Have you seen anything on those videos that you found in violation of any civil statute or criminal statute as well? And and just be direct with me. So, so I can understand it. What was there anything that you saw that's a violation, or no, that there wasn't a violation?
I apologize. I'm going to give you an answer that I think is going to be really frustrating, President Flynn, and I apologize in advance. I actually have not watched videos of the conduct in front of the mayor's house. I, along with Rob and others, have certainly done research on the general legal questions.
Well, Adam, I don't need to cut you off.
Yeah, that's fine.
So has Rob seen the videos?
I'll let Rob speak.
Council President, I have not. I have not watched the videos.
Rob,
I apologize.
Rob, you guys got to look at them. It's hard to be in this conversation. And I like you guys. I have respect for you guys. I value the work you do. But it's hard to be in this conversation without seeing the videos. I need you guys to spend 30 minutes this weekend and take a look at the videos and tell us what you see in the videos, if there is any violation as a professional lawyer or as someone that's skilled in the law. But you can't really engage in this conversation unless you see the videos. And most people in the city have seen the video.
Allow me to, I appreciate and will follow up on that suggestion. But let me add one thing just from the law department's perspective, which is it is clear sort of what the event in our community that has prompted this legislative action or inquiry is. But from the law department's perspective, that is sort of routine. There's always, not always, there's almost always some crystallizing event in the world that highlights for the legislative or lawmaking bodies the need to deal with something. But then the law department really is looking at this as just the ordinance as written, which is going to, if it were enacted, will apply, it's just to everybody across the board throughout the city. So.
All right, thank you. Thank you, Adam, and respect you and respect the work that you do. I appreciate you being here.
Thank you, Mr. President.
Thank you, President Flynn, and thank you for your leadership as always. Councilor Edwards, and then I'll make my questions very short so that we can get Councilor Lara before her time stop. But Councilor Edwards.
Thank you. With regards to the specific ordinance, in reading the mayor's submitted letter, that this is meant to enhance or at least to add to the tools in the toolbox with regards to noise and other enforcement, I guess, against forms of nuisance. Is this the first time that our city ordinances have called out specifically residential picketing? Is this the first time we've dealt with residential protesting?
As far as I know, it is.
Okay. So so it's two things that are happening. It's not just a 2-hour shift to the noise ordinance. It's specifically calling out a specific activity, protesting, picketing, demonstrating, and also making sure that those activities are happening within 9 p.m. and 9 a.m. Specific, those two major things, right? And so naturally, of course, when those rights are the right to assemble, the right to protest and redress, they're in our Constitution, that the government has called out those particular rights is a natural concern for me and other people. The reason why I do support some form of curtailing or at least time, place restrictions on those, and these are rights, is because I believe that certain times in which they happen go from being attempts to redress your local government to just outright harass or cause harm. I also think the timing and the noise level that is chosen, it's the two combined together that I believe are intended to cause harm. So I do support, in general, a 9 to 9 p.m. Redress kind of, 9 p.m. to 9 a.m., excuse me, redress hour, but I don't support it simply outright. You know, one of the letters we were submitted today was from George Lee, where he noted somebody who was sleeping outside a person's home could be accused of under this ordinance, and therefore be arrested or removed or cited for being just physically there. I guess silent protests at 3 a.m. or silent protests that do not block sidewalks. There needs to be some more context for what the protest is, for why I would make sure that it only happens within certain hours is my concern, is really my concern, Adam and Rob. So are the definitions of what is picketing, what is demonstrating, it's pretty broad, that activity, right? That you're limiting to certain timetables. And some of that activity does not cause harm. Some of it doesn't. If it's quiet, if it's one person, if it's, you know, someone who's specifically targeting a person or a business that is, you know, open 24 hours, or I'm sorry, a business that's within a residential neighborhood or a person who has a business. I think my concern is that there's no context put on these terms. There's no context for what is the protest. If the only thing is, if it's loud and noise causing and it's over the decibel marks, then I think in those hours, it stops being redress, protest, protected constitutional activity. It goes right directly into the noise ordinance. So are you open to maybe narrowing or defining those words a little bit more, or putting some context? Protest or redress that happens and causes noise of any kind shall be between certain hours. And I mean, I appreciate Superintendent Bailey bringing up, you know, what happened at my home and 8 other city councilors' homes in the middle of the night, right? They came in quiet to protest our budget votes. And my house wasn't as defaced as others, but they did come in the middle of the night and put things all over our homes. And, you know, what we did is we addressed them. Those who chose to go to the police went to the police and filed complaints. You know, I don't believe that certainly wasn't an attempt at free speech, right? It was I didn't feel that way. There was no message delivered. The action had already happened, but whatever, the action happened and we had the right to go to and file complaints if we wanted to. So I think my concern is there's no definition of this activity. What's a demonstration? Do you know how many millions of forms of ways in which someone could be demonstrating, picketing, redressing, and not all of them cause the same harm? If it is a quiet demonstration, if I am standing outside my assailant's home who caused me harm or caused my child harm, and I'm in a silent protest or in a hunger strike outside their home at 7 a.m., I am not blocking a sidewalk, I would be cited by this ordinance. So could there at least be some kind of harm that causes harm or is intended to cause harm as a standard? So if it's these activities that are intended to cause harm, or sorry, I shouldn't say intended to cause harm because they would be banned, intended to cause certain noise levels or intent and block access to streets, or, you know, there's got to be something that is added in a context that these activities are causing. I believe quite firmly, you know, the 9 to 9 is reasonable, because I do believe a loud protest at 7 a.m. isn't meant to deliver a message at all. It's meant to cause harm, but it's because it's loud and it's at 7 a.m. not because it's just a protest at 7 a.m., which could be quiet, which could be a hunger strike, which could be a sign, which could be a lot of things, and which could unintentionally be defined to include children crying outside, people sleeping and homeless people sleeping in front of your home. You can be overly inclusive of certain activities. So I would love for the creativity of this conversation to come up with some context, because I do want to support this. I absolutely want to support a 9 p.m. to 9 a.m. Restriction on certain activities that block public way, that rise above the noise level, a decibel level, or and you can pick the decibel level. It could be, for me, if it's 3 a.m., I don't need I think 70 is too high for 3 a.m. I would put it even lower. But that do these things, the time and the noise level, I would want those restrictions to be put in. So that's what I think the time we have. What we don't have is the noise level. If you can put that in there, I would support this, because I believe at that point it's causing harm. So.
I think that is a question for you, Corporate Counsel, to answer.
Well, I not to disagree. But we are.
Look if you do.
Yeah. We are, I think, totally happy to review any language or dig into any language. I don't think that we can, just because we work with language a lot, start offering changes to the policy. This body certainly can, and we're happy to sort of work with you and engage in that conversation. And I think that, so I mean, I guess that's all I can really say right now, which is we are always very willing to look at proposed language, whether it's right here in the working session or any other context. And I see what you're talking about, Councillor Edwards.
Would it make sense then? This would be my language proposal or my suggestion. I know, Councillor Roy, I have to leave. I know, and I will send it to you in an email ultimately. But if you were to flip the ordinance to simply say there shall be no, and then all the verbs that you have, protesting, picketing, such and such, over 50 decibels between the hours of 9 p.m. and 9 a.m. or over 20 decibels, whatever the decibel number is, and just flip it so that there's an actual quiet hour time for that activity. My thoughts might be to do to do that. Again, because I do think you may run into a constitutional challenge of someone who just does a silent protest outside my house because they can't stand the traffic or whatever. A silent protest that doesn't block traffic, that doesn't wake me up or cause harm to children or elderly in my neighborhood, but happens to be at 8:30. I wonder.
Do you want me to address this, Adam? Or
I think there is one, Rob, please. I think there's a relevant comment in Frisbee here. But yes.
And Councillor, just to point out what you said, and this is speaking specifically to the silent protest, noise levels and such. In the decision in the Frisbee v. Schultz case, the significant government interest that was recognized was the interest that people have in privacy and protection within their homes. And one of the things they focused on was an individual who had targeted protesting outside of their home, regardless of the noise level, regardless of the amount of people, that a silent protest even could have the effect of having a person held captive in their home, feeling as if they can't leave their home, feeling as if they are being intimidated in their home, which can happen without noise. And the court specifically recognized that those sorts of protests do infringe on that significant government interest. So in terms of the constitutional issues that we may run into, the Frisbee v. Schultz case has addressed those types of constitutional issues and the types of harm that can be created by any type of targeted protest at a single residence.
And the government interest is the protection of privacy within the home.
Correct.
Mm-hmm. And so I think that the difference would be then, it might be, I know we're talking, it's not about the mayor of Boston or any of us as elected officials, but there might be a certain level, I wonder, the case law that says about my expectation of privacy within my home and residential as an elected official, where my address is put out every time, I'm sworn in and so on and so forth. And the expectations of my neighbors are different. I don't know. This doesn't make a distinction between the two. It's treating me and Michelle and Kendra and Ricardo like our, neighbors who are anonymous, non-elected, and not public servants, and not people who would be coming to them to redress necessarily their constitutional rights. So that there is no distinction might also be a problem, because I don't know of too many non-political figures who are getting targeted residential protests. So I'm inclined to lean in and support this despite these concerns. I want to be very clear about that. I also still think that there might be some, and I can send in some suggested scrivening words that might help to narrowly tailor it. But I do think that there's going to be a concern when it's a silent protest outside someone's house. And it would be on, the person who's being protested to prove that it intimidated them, violated their privacy. I understand the burden of proof would be on them or on the government who tried to enforce it. So, but thank you so much for this. I appreciate it. And I think that that's it for my questions. And I will send to all my colleagues, I will send my suggestions to everybody at the same time.
Thank you, Councilor Edwards. Councilor Lara, I'm going to skip through my questions. I'll put them at the back end because I know you have a time constraint. So if you'd like to make your suggested language changes now.
Thank you, Chair. And, I wanted to say, as I'm listening to Councilor Edwards' remarks, that, if we were just, that the noise is not the purpose of the ordinance. And I think that Adam and Rob shared this in our thing. So if that was the case, then we would just be making edits to the noise ordinance to extend it or lower it. And so it's been very clear that this quality of life issue is not necessarily about the noise, even though those are the complaints that we're getting from folks, and that other attempts, at least on my end from my office, to kind of tailor it even more would then make it not content neutral, right? Like tailoring it to like specific kinds of protests or things that we would then make it not content neutral, which is some of the difficulty that I'm finding and trying to zoom into it. So thank you, Chair, for letting me go first. I have a young child that I have to get off the school bus, so I want to make sure that I share my remarks. So you've already answered these questions for me, but I would like for the record to share, similar to what Councilor Edwards is kind of the backline to that, what kind of protest would be suggested to this ordinance. So we have a really vibrant housing justice movement in the city of Boston. So would something like an early morning foreclosure auction or an eviction blockade be subject to the ordinance? Unfortunately, sometimes in the city of Boston, we lose young people to gun violence. And people and community members often gather in what could be described as a demonstration outside of the deceased person's home. If someone calls the police, would they also be subjected to these kinds of fines?
Rob, do you want me to take a quick crack at this? I am not familiar enough with like an early morning eviction action or a foreclosure auction action, but I will I guess, just go back to the language of the proposed ordinance, which is that it is picketing, protesting, or demonstrating that is specifically directed towards a particular residence or the occupants of the residence, and what takes place there. So in your scenario, clearly there is a form of protest taking place before or about a specific targeted residence. However, I do not think that it's directed towards the house or the occupants of the house. I imagine the house is sort of owned by a bank, and I might be misunderstanding something, but the protest is directed at the financial institution. So if I'm constructing that hypothetical correctly, and I realize I may not be, this ordinance would only hit one of two parts of the definition of targeted residential picketing in this ordinance.
So they would, these do target a residence, so they would be subject to the ordinance. Like an eviction blockade, to use as an example, folks would be showing up to someone's home to stop an eviction from happening, to prevent entry either to the home or to stop people's homes from moving out. And so you're saying that that would not be considered something that would be targeting a residence.
You know, obviously everything would be, you know, I'd have to understand the facts even more, but I don't think that that's a protest. It's not a protest directed at the resident, at the residence. It's a protest directed at the financial institution. But.
Yeah, if I can just really quick, just to try and legalese.
Thank you, Chair.
I hear like, so basically what I think you're trying to say, Adam, and you correct me if I'm wrong on this, is that this paragraph, they need to hit every single point on it. So basically it's picketing, protesting, or demonstrating specifically a particular residence or the occupants of the residence, right? And so I think the question here is the residence itself is obviously the focus on a foreclosure proceeding, right? So if there's a foreclosure proceeding, it's the resident. Nobody's targeting the individual who lives in the home. They may be targeting the financial institution that is trying to take that home.
Unless we are talking about a landlord occupied home, which is.
Unless we're talking about a landlord occupied home, which is a good distinction. And so there's a couple different levels here. You could be talking about a landlord level occupied home. You could be talking about a home that has somebody who still lives there, who is trying to protect and keep their own home. And you might have a home that the bank is in possession of. Essentially, with the targeting of a residence like that, even if you're not targeting, though you could be in the landlord version, the individual who lives in the home, would this apply to that?
I think it's no, and yes.
So if it's targeting,
I will concede. I think that in the landlord occupied home example, the landlord is going back to my prior example, the landlord is in the shoes of the financial institution, right? So yes, if the protest is directed at that person's residence, like where they live, and it's there, I believe that it would apply.
Okay. So I have, my suggested change, I have two suggested changes to the ordinance and the language. I think it's around the definition of what we're defining as targeted residential picketing. Right now it reads picketing, protesting, or demonstrating with or without signs that is specifically directed towards. And so the use of towards leaves it open to whether it's a positive or a negative demonstration. And so my suggestion would be, and my request, if we can change the language of towards to either against or in opposition of. Because if somebody's outside celebrating something, or like we don't, the answer to the question that I just asked being unclear means that we need to be clearer about what we're trying to say. So somebody, for example, going to someone's home and trying to stop them from being evicted is a protest or a demonstration that is in support of the people who live in that home. And so can we specify that this is against or in opposition of? And the second part of it, which says it says a particular residence or one or more occupants. Can we remove a particular residence altogether and just have it be specific to one or more occupants within a residence? Because I think that that would also remove some of the gray area about if someone's outside hosting a foreclosure, right, or having a memorial or something outside of their home. It also removes some of that gray area, because a residence is like is a physical building. It's like it could be any place where anybody lives, whether or not they're targeting the people who live there. And so if we're trying to stop, I think the ordinance will do the same thing if we remove residence and say one or more occupants of the residence. I think it still gets the point across. The last thing that I have, that I think it's question and suggestion, particularly because of the gray area of what could be and what could not be considered. Is the violation of this ordinance as written right now considered like illegal, like considered to be an infraction legally? And can you, for the record, share with folks what an infraction is?
So just to be clear, Councilor Lara, you mean whether or not it's a civil or criminal infraction?
Ultimately, yes. Or if it's considered like a, like a violation or an infraction.
Or like a parking ticket, basically?
Yes.
So Corporation Counsel, I think.
My understanding is that it does, but I want to.
You want on the record. Corporation Counsel.
If I understand the question, yes. It's not criminal. It is a ticket. Rob, do you have a little bit of a criminal background than I do, so.
Yeah, no, this would not qualify as any sort of criminal violation. Criminal violations need to be derived from state statute. The city doesn't have the ability to promulgate ordinances or pass ordinances that would attach criminal liability to individuals. Those types of laws need to come from the state.
Beautiful. And so because it's civil and it's an infraction and not criminal, that means that it doesn't hold the possibility of any jail time, correct?
Correct.
Correct.
So that means that the person who is receiving the violation is not entitled to a jury trial. So what does the appeals process look like for somebody who is receiving one of these violations? If I think that I am being given a violation and a ticket in error, what do I do?
Do either of you know?
I do not know specifically. You would challenge it at the like clerk magistrate in the district court. I don't know what the specific process is, and
but I would have to go to court
get back
to challenge it. I would have to go to court to challenge it.
I think so. I guess the question I have for this is, would they be going to a courthouse for this, for an infraction like this? Or would they be going to the city itself, the way people challenge parking tickets and other sort of city versions of tickets that come, for instance, I'll give you a version I get called for as a counselor is, I got a ticket because my grass was too long or whatever it is. That doesn't go to a criminal court. My understanding is it goes to the city. Would this go to the city for that, or would this end up going to the local, criminal jurisdiction court? So whether that's West Roxbury, Charlestown, or wherever they're headed.
It would be the local court, because there's no sort of specific administrative process set up for this at the city level. But it's still a non-criminal disposition.
But still requires the time and effort and energy that it would take to go in and appeal if people feel like they were wrongly given the ticket.
Correct.
Great. So my suggestion on that, my variable suggestion, 86 the fine. Obviously, that's a long shot. 86 the fine is my suggestion for the record. And if not, there needs to be clarity of process, whether it be written in the ordinance or shared with the city council about how people appeal this. Because if there is in any way, shape, or form, if it could create more of a problem for Black and brown people who are protesting, who are mostly the people who are going to be disproportionately impacted by this, then we need to know that if it's going to be at any point in the implementation, I want to be aware of what needs to be worked out and what kinks need to be worked out. So if there is a process that currently exists, I would request clarity on that process. And if there's not, request that one be created, and better yet, that there be no fine attached to this ordinance. That is all that I have in terms of.
Councilor Lara, this is a question. What do you have any suggestions for what violation of this ordinance should lead to? Like, I guess is the question, if it's not a financial fine and we're trying not to criminalize it and send it to criminal court, do you have a suggestion period as to what sort of result should come about violation of this ordinance?
Yeah, removal from the location. I don't think that there needs to be any, $100, $200, $300 fines for the folks that can afford them are going to be nothing. They will pay them. These folks will run a GoFundMe and get their people who are all supportive of them to pay for their fines. It's not going to be a deterrent. It is going to be a deterrent for people who can't afford those fines, and for people who think that they receive the fines in error, who have to waste time, energy, and resources to go to court to appeal it, and so on and so forth. So ultimately, there's only one group of people that's going to lose out with these fines. Removal from the premises fixes the issue of removing people from wherever they're protesting and so on and so forth. I don't think that there needs to be a fine attached to it at all, because I don't think that the fine is a deterrent for these folks. So.
And so I just got to be, I guess this is a question on that to Superintendent Bailey. You know, from a criminal law standpoint, that certainly sounds like detention and arrest to remove somebody by force. I guess the question is, am I incorrect in the understanding that there's no, like, in terms of removal, if they refuse to remove themselves, then that would essentially, in order to effectuate that removal, it would have to be through an arrest. Is that accurate, Superintendent Bailey? You're muted. Sorry about that. You are muted.
I'm sorry, sir. You're exactly right. There would have to be some sort of probable cause for a violation of law. Just, you know, the council has raised good points, Councilor Edwards as well. You know, we've talked to the neighbors out at the mayor's house. They've been out there in support of her sometimes. We've had community meetings with the neighbors as well. But as far as, you know, a non-monetary fine here, there would have to be some sort of probable cause of violation of a law to move somebody.
So removal is not an option. So if the fines are the only option for any kind of enforcement, then I would significantly lower them.
And so, okay, so that's one option. And then the other one I think you wanted was sort of an understanding of what the appeal process would be if they had to do this if somebody got this and wanted to challenge it, sort of more definition around the appeal process. Okay, I just want to make sure.
Yeah, and the change in language around residents, like the definition of residential picketing.
Which I want to get to before we leave to the next person. Corporation Counsel, if I remember correctly in my own notes on what you suggested, Councilor Warren, you can throw them out there as well. Would there be any issue with changing towards into against from a legal standpoint?
Or in opposition to?
Or opposition to? Does that get into the content neutrality?
Sorry, I'm going to give you a frustrating answer, and I apologize.
I'm an attorney. They're all frustrated.
Yeah, this is going to be one of those examples of, like, you know, we're getting a legal question here in real time, which is I think a really interesting one. And I think we're going to ask for, you know, we will need to look at that rather than just give you a verbal offer.
Perfectly. So let me just be clear. That's perfectly fine. And then the second part of that edit was to remove particular residence, but leave one or more occupants of a residence. Do you see any issue with the removal of particular residence if it still contains the one or more occupants of a residence? So in other words, the protesting or picketing of, say, an empty home wouldn't lead to any issues on this. But if it has an occupant who is the subject of the protest in and of itself, it would. Do you see any issues with the removal of particular residents?
Sorry, before I say anything, I want to back up 1 second because I actually had a slightly different understanding than what you just laid out, Chair Arroyo, and I just want to make sure. Are you asking, in your scenario there, are you saying that it would hinge on whether somebody is home right then?
No.
Which is not something I thought about. But.
No.
No,
Okay.
no, it doesn't. I think if someone doesn't have to be physically in the home. If they live there, it's fine, but more so removing, because it already says on the second half, you know, in the residence, and which takes place before or about the targeted residence. So that's already there. And so removing a particular residence, I think would make it clearer, but it would also kind of remove some of the ambiguity of like an eviction, you know, like an eviction blockade, which is not necessarily targeting an individual. Like if the landlord doesn't live at the house, it's not targeting anyone at the home, but it's still a demonstration at the house.
So I'll reread that sentence out loud for folks who are at home trying to figure out what we were talking about, and also for the benefit of Corporation Counsel. So the way that it is currently written, it says, for the purpose of this section, targeted residential picketing means picketing, protesting, or demonstrating with or without signs that is specifically directed towards a particular residence or one or more occupants of the residence and which takes place before or about the targeted residence. The proposed change here, specifically regarding a particular residence, would lead to a sentence that says, for the purpose of this section, targeted residential picketing means picketing, protesting, or demonstrating with or without signs that is specifically directed towards one or more occupants of the residence and which takes place before or about the targeted residence.
So with the caveat of what I just said before, this seems a little easier, and I think it's my instinct is that it says the same thing that I think was intended, and if the council thinks it's clearer, I don't think that this office.
I
think it's clear now. I think that just removing that part removes some of the ambiguity of like whether or not it's a specific home only versus like protesting.
So an individual who lives there. I think this gets to the point that we're trying to get to, which is we don't want people necessarily targeting somebody's home because they live in it at these hours. Getting the particular residence out means that they now can no longer, it doesn't matter if the occupant is currently there, it's the home that they occupy. I think the idea here is to stop people from targeting the occupants of homes, not the homes themselves. And this gets rid of that ambiguity, I think, as well.
Chair Arroyo, I think we agree. I mean, and certainly that is the intent. The intent is about, you know, the word residence, it's supposed to be a meaningful thing, right? Where somebody lives, not the fact that structurally it is a house. So I think that we're probably on the same page here.
Yeah, and I obviously you got to take that back, and so I think everybody should just understand you're going to take that back to the team and go through it and make sure there's no legal issues that you find in other cases. But I think that's actually a pretty solid edit there that I would suggest we look at, and then you can come back with whether or not changing towards into opposition or against deals with the content neutrality, which I know you have to juggle when we're dealing with things like this. And then I think the second part on defines is something we can look at as well, whether it's decreasing the amount of the fine or trying to clarify the appeal process. I think we can look at those three things. Councilor Lara, I have 3 changes there. Are there any other changes that you would like to offer up?
No, that's all. I just want to extend my thanks to council, to Adam and Rob, and to Superintendent Bailey for answering all of our very nitty-gritty questions and bearing with us as we try to get this ordinance right, and to the chair for allowing me to get my questions before I had to leave. I am going to head out now, and so I will look forward to hearing where we land in the future. So thank you.
Thank you, Councilor Lara. And now I'll go into my questions, since I wanted to make sure I gave Councilor Lara time to get those presented. I know that one of the major concerns here is the idea of the defining of a residential. The particular residence, as opposed to one or more occupants, I think is very important for the thing I'm about to bring up next, which is we have union actions We have folks who strike hotels, which could be determined to be a residence. But I think if you change the language to specify that it's not the residence itself, but the occupants of the residence who are protected from 9 p.m. to 9 a.m. I think so. The removal of particular residence, and you can tell me if you think I'm wrong, but I think the removal of those two words actually ensures that, say, a hotel strike action that is about the hotel company and not about whoever lives at this hotel is protected when you remove particular residence. Unless, of course, the hotel owner somehow lives at that hotel. I think this actually deals with that. Does that sound right? And I can clarify that more if that was unclear.
It was not unclear, and I agree. Actually, I think I probably would have read it the same either way, but I think you're certainly right. In the formulation that you're talking about right now, I think that a strike or a picket directed at, say, the company that owns a hotel, absent that weird situation, wouldn't be subject to this. Again, this is about people being.
Unless that's what it is. So again, this wouldn't apply to that. And then I guess another question that I have fielded from folks is rallies, schools, like if students walk out of their school and have sort of a rally near a residential area, because this doesn't directly, and this with no changes, just as it's written, because it doesn't directly address a residence or the occupants of a residence, events at schools or events of business in a residential area or any of those kinds of things are not subject to this, correct?
Yes, correct.
Yeah, correct.
Yeah. So basically, if somebody wanted to go and picket the neighborhood pizza shop, even though it's surrounded by a bunch of homes, this doesn't apply to that because it's a business. Same thing with other businesses, same thing with schools. This applies specifically to residential homes. Is that accurate?
Correct.
And then if we make that edit where we remove particular residence, it goes one step further, which means it's not even about the individual home anymore, but whether or not you're targeting directly the occupant of that home.
Can I mention one concern about that?
This is the time.
My only concern, and the reason it's a concern and the reason I thought of it is because it's you talking now, and I think about the situation at your mother's home.
Yes.
Whereas if we say it's targeting occupants of the home, in that case, they meant to target you would think. So
I would assume that was what they were trying to do. I mean, the thing is,
so if they make a mistake,
so let me just give you sort of a factual aspect to what happened, though. When they targeted my mother's home, they were informed by my mother and several neighbors that was actually my mother's home and not where I live. When that occurred, they made a decision to continue to protest my mother's home and essentially demand my address and where I was and to have me come. But they continued to protest my mother directly. I think once they make that change, once they are informed of the error, right, and they decide to continue to protest, say, my mother, as they did here, or anybody, I think you've now shifted it from being a target where you're targeting me. But once you've been informed, or whatever person, whatever occupant of the home, once you've been informed that person is not an occupant and you continue to go after that home, I do think that changes the circumstances. And now this would apply even if they've made a mistake. Do we agree with that? Once somebody says the person you're targeting isn't here and this isn't their home, and they continue to target that home, wouldn't it still apply because now they're targeting the people who actually live there, who've informed them that the person that they're allegedly going after doesn't live there? Legally, that's how I would read it, but I'm happy to hear whether or not you guys see it differently.
I don't know if I necessarily see it differently, though I do think it could lead to some confusion in situations where people may target the wrong home.
And so, which I think part of the reason, I will just say as well, this is part of the reason why I think this is necessary. The fact of the matter is people will target wrong homes. People will make these kinds of mistakes. or they'll do it on purpose. But either way, the reality is it's something that is happening. You know, I will just say for Superintendent Bailey, this question, have you ever, and I don't know how long you've been with BPD, but I assume it's been a while. Have you ever seen this kind of sustained demonstration at any individual's home for this amount of time with this sort of consistency? Yes, it's not every day, but it's every week in some way, shape, or form. Have you seen this ever in the city of Boston?
Councilor Arroyo, I've been a police officer for 33 years. And we've had, periodically demonstrations at residences, but for a sustained period of time, particularly, I know your house and your mother's house was affected as well, Councilor Arroyo. But as far as the mayor's house goes, I have not seen that for that amount duration of time. No.
No, and I haven't seen that either. I have seen one-offs. They came to my house once. They came to my mother's house once. I've seen that before. I've even seen maybe 2 or 3, right? But in some stretch of time, not necessarily back to back to back. I've never seen weeks on end. And so I think that it's a new issue. So for folks who are watching this and they're trying to figure out why there's an ordinance on the table right now, we haven't had this issue before. We haven't had to really confront people going to residential neighborhoods in this way and in this form. I think it speaks to where we are from a civility standpoint. I think it speaks to where we are in a polarization of political opinion standpoint. And I do think there's a risk here to normalizing the going to residential homes, because I think it's dangerous. I just got to be honest with that. I think it's a real problem. I think there's neighbors who it targets. I'll just say this. My mother was very concerned about an elderly woman who lives in our cul-de-sac who was home and is in ill health, and the impact that it had on them. And I think part of the issue here that I have seen consistently, it's certainly true for my home. I don't think there's so much concern personally for the individual as much as it's the way that it impacts so many other people. And I think that's part of what we're trying to get to with this ordinance. And so I guess the question on the issue that you raised, which is what happens in the instance where they choose somebody else by accident or on purpose, who is not an elected official, not an office holder, may be tangibly related, may not be. Does this continue to address that if you take out particular residents? And I think it does, because the idea is we can say 1 or more occupants and just remove of the residents. If you take out, so for instance, if you just off of that, and I'll let you take it back to the legal team and find out whether or not that works. But if you take it back and just say, and I'm going to strike particular residents for this example and read it the way it would read if I wrote it right now, it would be that is specifically directed towards 1 or more occupants in which takes place before or about the targeted residence, right? Because that's one way you could do it. Or, I just think there's a way. Well, actually, it's still there. If you take out directed towards a particular residence and say, or 1 or more occupants of the residence, I think anything happening outside the house, even if they're not yelling about the individual in the house, is targeting that individual. I mean, unless they're looking the other way. I mean, I'm just trying to figure out how you could make the argument legally that a demonstration in front of somebody's home isn't targeting the occupants of that home, even if they're yelling about the president or, the park 3 miles away or whatever it may be. Anything happening outside of a residence that somebody lives in that is directed in the form of shouting or yelling or signs pointed at that residence on purpose or blocking of the sidewalk of that residence. I just don't see how. You'd have to be a very good lawyer, I think, to explain why this doesn't apply to the occupants of that home, even if that's not who they're quote unquote targeting. But I'll let you take that back to the legal team and make sure that holds up. I don't have any other questions. I just want to make sure that, some of the things that Councilor Lara brought up are important to me as well. I want to make sure folks that are trying to fight to make sure that they're not being evicted aren't the targets of these. I want to make sure that we're not making it difficult for our unions to picket their hotel spaces, which I think this doesn't do. I think this is very clear, but if we can define the language in a way that makes it very definitive so that there's no ambiguity, I want to do that. I will just say as the chair, I'm not interested in seeing this turn into something that could lead to arrest. So I don't want that. So from the standpoint of the options that were left on the table, if you remove that from Councilor Lara, I would look at maybe the fine structure and maybe make the front fine lower, but the back fine higher. And so what I mean by that is if you do it one time, maybe the fine is less than 100, but if you do it a second and a third time, now the escalators are a little bit higher so that we're actually getting towards repetitive actions rather than solitary. And I will just say, one of the questions that I have on the language here, because it's one that I would certainly parse about if I were an attorney trying to represent somebody on something like this. When we say subsequent offense, we have a situation here where are we talking about consecutive subsequent offenses in the term of someone's life? So you've done this once in 1998, now you're doing it in 2008, there's your second offense? Or are we doing it in the term of a specific amount of time? How are we defining when a subsequent offense takes place? If you get what I'm saying. And so just, is it consequential? Is it sequential? Is it by years? Is it ever? Like, how are we determining that? And I don't think there's any clarity to that. I'm not sure you have an answer for that right now, but I think defining that might be better, unless there's some general common law understanding of what that means.
We will, I think it's partially a policy choice. So, you know, we're happy to, you know, suggest something to the committee. But
perfect.
Yeah,
and I just think, and then correct me if I'm wrong, but when we're talking about narrowly tailored and whether or not this meets constitutionality, the actual punishment is separate and apart from that, frankly, right? We could make the violation and what you're responsible for the violation, almost anything we seek to make it within reason. But that changing the language of the fine structure or how we apply the fine structure doesn't impact the constitutionality of the other aspects of this that are actually sort of the grid of it. Is that accurate? Yeah, I'm seeing heads nodding. That's yes. Okay, yes. So I'm going to end it there because I think that's everything that I have myself. I see 2 hands up. I will ask my other council colleagues if you have questions or things you would like to add to raise your Zoom hands so that we can take it to you. And I'm going to go in order that I saw the Zoom hands come up. Councilor Mejia, followed by Councilor Murphy, followed by Councilor Anderson. And I don't see any other hands up. So at that point, I'll do a last call and we can move on. So Councilor Mejia, the floor is yours.
Yeah, Superintendent Bailey and also General Counsel, thank you so much for just your patience and just answering these questions. We really do appreciate it. I mean, Councilor Arroyo for holding this down because you are the ultimate translator. So thank you for helping me articulate some of the things that I'm trying to get out here. So I want to just kind of underscore some of the things that Councilor Lara was talking about in terms of navigating the criminal justice system and having to go to court in terms of how difficult that is for so many people, right? So, and while I appreciate Adam and Rob saying that we don't have the structure within the city process to be able to internally manage, you know, the appeals process, I just think in the future, maybe even now or at some point, maybe we need to think about what that would look like from the city's perspective, because yeah, there's also the fines and the time. It does impact folks. So I'm just curious, Adam, if there's a way for us to look at the parking ticket situation and other citations. Is there a way for us to, in this particular case, and Councilor Arroyo, you know better than I, to have this something that goes through the city as opposed to the courts? Just curious. It's just a question. I'm just curious.
I have a quick answer, which is we obviously we are happy to look. I believe the answer is going to be that this remains like a fine, like many of the fines in our municipal code, that is issued under the council or under the city's authority under Chapter 40, Section 21D. So there are some which doesn't provide a sort of in-house mechanism, but it's certainly something we could look for. Some of those other mechanisms we are all familiar with, like, green tickets if I forget to shovel in front of my house, or a parking ticket. Those have different statutory schemes that underlie them. So I suspect the answer here is going to be, if you got a ticket, you'd either have to pay it or you'd have to go to the local district court to sort of tell the assistant clerk, here's why this is wrong. But that's just my sort of quick preview of what I think the answer is. We will certainly get back to the committee with that.
Thank you.
Thank you, Councilor Mejia. And I just think, just to be clear, sort of in common parlance, Corporation Council, is that because this ticket would be administered by BPD as opposed to, say, ISD or any of our other sort of city divisions? If it weren't BPD in charge of enforcement, would that change that process?
I don't think so. And we'll double check this, but it's really more about what the source of the city's fining authority is in the first place. So even if we assigned the ticket to the which would be wrong, the Noise Commission or the Air Pollution Control Commission, which would be the wrong fit, we would still confront the same process.
Understood. And I appreciate your attempt to answer that there. Councilor Murphy, the floor is yours. You're muted.
I'm ready. So I have a concrete example I would like clarification on to see if this ordinance was passed at this time, if I would have been in violation. Back on July 15th, I joined the Nurses Association, MNA, and we're striking at the chair of the Boston VNA Healthcare. She lives at the Bay Towers. And we went to her home and we were picketing to deliver a letter, and we did enter the lobby and ask if we could talk with her. And there was a group of us, and we were targeting, because she lived there. She lives in an apartment building, and I know there's been conversation about, well, if you live in a 3-family, then you're bothering your neighbors more than if you lived in a single family. She does live in the tower, but we specifically went, and I joined the union to go with, there were lots of us there. So would that be considered in violation of this order if this ordinance had passed or was in place at that time?
Rob, I'm going to give you a chance to jump in, but I'm going to start by reminding us that this ordinance as drafted allows residential picketing from 9 a.m. to 9 p.m.
Mm-hmm.
So that would make time an essential part of this.
Right.
You remember, Councilor Murphy, what time?
Yeah, but if it was outside that time, right? No, I understand that we're trying to put it, like if we had gone 8 o'clock before we got to work to specifically deliver a letter and picket and, cause a little disruption to the other neighbors that,
So I think in that example, she's saying if they had done it at 8 a.m.
So it's 8 a.m.
Just say, right? I'm just trying to think of concrete for me. I'm trying to picture myself in places I've been. I know Councilor Lara had kind of done that too, giving specifics. So that specific example was not within the time limit, but I'm thinking we did target her. Like we weren't just trying to form, gather to show that we were together picketing. Like I've gone to lots of picket lines. This one was specifically at her home.
Yeah.
So it would, right?
But I mean, did you just say it wasn't though at that time frame?
No, let's assume it was 8 a.m.
Legally, did I break the law? I'm just giving an example.
Right. Well, you can't break the law. We have it passed. Let's be clear.
That's okay.
But in terms of, I just want to make sense of the example in terms of, so that they can give you the right answer.
No, so I guess the answer is answered, right? So if I go at 8 a.m. specifically with union members to picket someone's home who is the chair of the board, or I've done it before with unions where we're picketing the owner of a job site and we're not at the job site, we might be at, so I know that this happens in the union world too, when they're picketing. And oftentimes it does happen 7 a.m. because then they go to work, right? They're off to work. So that was just a clarification question because I was picturing myself in that situation. The other thing I do want to touch on, because I've heard a lot of my colleagues talking about the quality of life issues for the neighbors, and we're specifically talking about in the area here where the mayor lives. And I'm very empathetic. My own 80-year-old aunt lives only houses away from there. She lives on Poplar Street. So she does, when it was loud, she could hear it at her home. But it makes me think that we're going to have a lot of hearings in our future addressing violations of quality of life issues for neighbors who live in different neighborhoods across the city. Because what we were talking about earlier made me think about, the neighbors who live near Mass and Cass, and they've been crying, right, for years for the city to address, the discretion that has been asked for people to put on, things that are happening down there, and it's caused a lot of pain in their lives and their quality of life, and they feel like their neighborhood, the schools, the businesses have suffered, right? So I just want to kind of put that out there, that it's making me think that we will have to address quality of life issues in a lot of other neighborhoods that neighbors have been saying. And we have been pushing back because we do want to take a different approach, and we do want to be empathetic to those struggling down there. And we do want to, not just arrest our way out of a social and mental and recovery issue, but it's just making me think of that. So I just want to put that out there. And lastly, so I just want to clarify, because I know it was said a while ago, because I do care about, and I am concerned about the mayor and her family. And I just want to clarify for the record once again. So this, I guess, would be for you, Officer Bailey. Am I correct to say, I just want to make sure it's true, that the BPD has put additional coverage at the mayor's house, that you're going to continue to protect her and her children, that you did say here at this hearing that Chief Long is in communication often, is it even daily, with the mayor to make sure that she feels safe, and that we as a city are doing everything we can to make sure that not just her, because we know her husband and her children live with her and her mother's downstairs, that her whole family in that house feel safe.
To answer your question, Councilor Murphy, without question, 100%, the role of the Boston Police Department is to protect the mayor, her family, her neighbors, and all the residents of the city of Boston. And we've put additional resources out there, Councilor Murphy. We'll continue to do that, and we'll do whatever is necessary to protect the mayor. That is our number one priority.
Thank you. I just wanted to make sure I heard that correctly in transition. That's all for now. Thank you.
Thank you, Councilor Murphy. And so I see Officer Bailey, Superintendent Bailey, your hand is up. I don't know if you had something you wanted to add or if that was just an accident.
Sir, I just wanted to, I know we're getting towards the end of this, I believe, and I just wanted to make some final comments, if that's all right.
It's absolutely all right. Do you want to wait till after we go through the last two counselors and then let everybody else speak? Okay.
Fine,
if you have a time constraint, just let me know, and I'll be happy to cut right to you. But I think we're wrapping here. Councilor Anderson, followed by Councilor Louis-Jean.
Thank you, Mr. Chairman. I just want to reiterate my point again that, it's important for us to distinguish the parameters between picketing and drawing the lines where it overlaps harassment. And, I heard my colleagues' points. Again, like I applaud my colleague, Lara, Councilor Lara, for her points about, if laws pass, there's a concern about whether or not, how it will be used and who will be used against. And, the more power to one side with implicit bias, what does that mean for Black, poor, immigrant, and otherwise, and who would feel that power, right? And then my colleague Edwards, Lady Edwards, in terms of stipulating, specifics and not violating the constitutional or facing those challenges. And I really appreciated what Councilor Louis-Jean had to say about comparing patterns in the past in terms of other incidences that are like this and how were they handled. And I just, and I think, Mr. Chair, you made this point as well, like, if we, I'm just gonna say it. Well, if our mayor was white, a white man, would this be the situation? Like the fact that I think we already have the law that addresses this. Like, it's not like we need a new law. It's, you know what I mean? Like, we already have the laws that we need in place, but the fact that this mayor has to, or not necessarily that it's just about her, but overall has to go the additional and stipulate and figure out how we can amend and all of this just so that people are not feeling harassed or safe. I mean, the Constitution clearly states that it's about peacefully protesting, expressing, not in this manner. Again, we are not talking about the First Amendment. This is something totally different. And I believe that had she been of other demographic, she would not be having to face this issue. And that is the point, isn't it? Why have we seen this before? No. To this magnitude, no. To this point, no. To this harassment level, no. So what's the difference? What is different about this mayor than the other ones who have taken other positions of opposition, of strong opposition on other issues and have not faced these repercussions? So I think that we should be honest if we're to lead with democracy and, you know, justice. And I really appreciate the harm reducing approach to address the possible mental health issue, instability. I mean, let's think about that. It's not just the people at home that are impacted, right? And the aftermath of what the traumas that, or the visceral trauma that our neighbors can face, but also, I mean, are these people on a clock? Are they getting paid? Think about it, like day after day after day after day for 10 weeks, like really? Who's paying these people? And if not, then what are we talking about? Are there some levels of instability? Because who does this? So I just have to express that overall, like I feel like with laws that we already have in place, we should make sure that people feel protected already. And this is not picketing. This is something totally different. Thank you for indulging me, and thank you to everyone.
Looks like it muted there, Tanya, on the end. You're saying thank you for indulging me.
I was just thanking everyone, and hopefully we get the result that we want out of this. I appreciate this. Thank you.
Thank you, Councilor Anderson. I'll just add a small thing there about people feeling safe. I think one of the things that was so frustrating about what occurred to my mother, but also to the neighbors around there, is that she did not feel safe in that moment. And I think that whether or not we are able to create some sort of ordinance that offers protection to folks in that situation, whether they're my mother, her neighbors, someone else's mother, whether we're doing that in that way, I think is incredibly important, because again, we want folks to feel safe in their homes. I think that's the whole purpose here. I think everybody feels like they deserve the right to feel safe in their homes. I think some folks can make an argument if they want about why you forfeit, or why your family forfeits the right to feel safe in their home if somebody seeks public office. But regardless of whether or not you hold those feelings, I think everybody overall would agree that people should feel safe in their homes. And so the idea here is to create this. And I do want to just say, for folks who have stuck it out through all of this still provides 12 hours of the day for you to go and do this outside of, say, my mother's home, and make her feel unsafe. If that was the goal, this doesn't stop you from doing that. You could do this from 9 a.m. to 9 p.m. It doesn't actually stop that behavior. If you wanted to go to Mayor Wu's house and you wanted to do it from 9 a.m. to 9 p.m. and just do all of the stuff that we're seeing every day, this ordinance wouldn't change that. This literally just says from 9 p.m. to 9 a.m., we are asking you to be civil in residential neighborhoods. That's legitimately it. If you wanted to go do the exact same thing, you get to go do that from 9 a.m. to 9 p.m. There are 24 hours in a day. You have been left with 50% of those hours, 12 hours, to go do that if that's what you are seeking to do. And so I think this is narrowly tailored as it's written. I think, frankly, I have concerns about our inability to protect neighbors and protect folks like my mom and people who are going to have these kinds of things happen as they become sort of normalized. But I do think that this is narrowly tailored in that. And I just want to add that there, because There's been a lot about protecting the mayor and protecting this person. My mom doesn't have a detail. Neighbors don't have details. That's not how this works. And so when we talk about who this impacts, it's not just about Mayor Wu. It's been awful. And I think many of my council colleagues are correct in the reasonings for why it's occurring to her and the way that it's occurring to her and for the prolonged periods in which it's occurring to her. But this isn't just about her. There are other folks being involved. I have seen the videos of Ed Flynn with his son being harassed all the way down to a car, 2 or 3 blocks. We are talking about folks who did not sign up for this. I am very aware that for folks who have a grievance with government, for some of them, all things on the table are acceptable. I remember answering phone calls at my parents' home back when landlines existed that included death threats for my father. I remember those things. And so when we are talking about civility and where we are, I worry often about Michelle Wu's children. I worry about her mother. I worry about neighbors. I worry about my mother. I worry about my neighbors. And so I just want to refocus the ordinance's issue here isn't just protecting the mayor. It's trying to create something that allows us to protect neighborhoods in general from the hours of 9 p.m. to 9 a.m. from this kind of targeted emotional harassment. Because ultimately, you can physically harm someone, but we are now in the year 2022, and we know you can emotionally inflict distress. There are ways to do that. And so, whether or not, BPD is able to protect Michelle Wu's physical being doesn't mean that they're able to protect whether or not her children are being exposed to people calling her a literal Nazi or evil, or that she is going to die or go to jail or to do any of those things, which is what have happened on video. And so when we talk about 7 and 8 and 9-year-old children hearing that about their parents, and we can create something that says you cannot do that, at least before they go to school, I really don't, I have a hard time, I gotta be honest, being outraged in any way about this ordinance or thinking that this ordinance is unfair. I can't get there. Like I hear people who are outraged about the idea that we are somehow infringing on First Amendment rights because you can't yell at children at 7:30 in the morning. I think the fact that we still allow you to do it at 9 a.m. Is probably too much, frankly. But that is what this will allow you to still do. And so, just know that's where I am on it. I think if we can make some tightening language on the ambiguity of it, that's important to me. Just making it more tight in that way. But I do not think in any way, shape, or form giving people 12 hours to continue to practice incivility is somehow restrictive. But Councilor Louis-Jean, I see your hand's been up. I appreciate you giving me as chair this indulgence to sort of state it plainly. Councilor Louis-Jean, whatever questions you would like to do, and then I will go to you, Superintendent Bailey, and then to anybody else on the panel who would like to give last remarks.
Thank you, Chair. And I just wanted to make just a few comments. I also agree in terms of a narrow tailoring. I think, but there may be a gap in between, like what, Erin, for example, brought up the case of the protest that she went to, and I went to that protest too, and I've been to many a protest, and that was probably one of the most genteel that I went to. And at the time, it would not have been covered under this ordinance because of the time of the protest, right? The time of the protest was in the afternoon, but based on the black letter of the ordinance, had it been a letter that we were trying to deliver en masse at 8 a.m., it would have fallen under this ordinance. And so I believe that, there are some legitimate questions being asked about the breadth of that without it sort of, with even though it's still, I think would withstand any constitutional challenge. So I'm looking forward to see how we implement some changes to the ordinance. But I'm actually even more curious to see the data from Superintendent Bailey, if we could get it, about my previous questions around enforcement on unreasonable noise, disturbing the peace, and blocking roads, to see. I think what Councilor Fernandez Anderson was saying, it was correct. Like, this is different, and is there a way to enforce what we currently have to prevent what's been really troubling and harmful to our mayor and to her neighbors? So I thank you all for being here, to the Office of Corporate Counsel, and also to BPD for being here, as we try to make sure that folks can still exercise their First Amendment rights and that folks feel safe in their homes. So thank you.
Thank you, Councilor Louis Jen. Superintendent Bailey, I want to give you a chance to speak, and I also want to echo the thanks that you've been receiving. I know this has been a lot of questions fired your way, and thank you for being here and answering them to the best of your ability.
Thank you, Councilor Arroyo, and thank you for having us. It's very important, obviously. And to go back to the, one of the first things said on this call was, I think it was Councilor Flynn talking about lack of civility. And that is, towards elected officials, towards our neighbors, towards the police, throughout society is appalling. And I think we're all in agreement on this call about that. As far as what you raised, Council Arroyo, I've never seen this. This is unprecedented about it being at, people's homes. We're all concerned about this type of behavior, and we can look at issues like mental health and the pandemic, COVID, isolation, things of that nature, but it's not an excuse for what's going on. I just want to assure people that the Boston Police Department, we have a long history of using discretion, de-escalation to manage situations in all our neighborhoods, including protests and demonstrations. Our officers use discretion, de-escalation hundreds of times a day. Okay, and we use the de-escalation and diversion negotiation skills to achieve the best outcomes in difficult situations every day throughout our city and all our neighborhoods. And just one thing I want to add, I talk a lot about de-escalation. I just want to let you know that the de-escalation tactics that I'm referring to have been paramount throughout the whole police reform bill, the legislation that just got signed last year. But, again, the Boston Police Department is committed to working together with the City Council, with all our residents, and support one another is more important for the benefit now more than ever for all the residents of the city. And we look forward to working with all of you. So I want to thank you again, Council Royal, and I appreciate your time and everyone else on the call. Thank you very much.
Thank you, Superintendent Bailey. And I do want to give the legal department a chance to speak. I do want to note that you're here. I am present and how appreciative I am of that. And I think the council as a whole is of that. I do think there's some urgency to try and make sure that we are getting this done in a timely fashion because we've seen sort of escalation in these sort of tactics. And so my question to you both, and I'm going to let you close, but we are wrapping here, is how quickly can we expect sort of the okays or the no's you can'ts on these edits to language and sort of the parameters of it so that we can get this process moving as quickly as possible?
Chair Arroyo, I'm happy to connect with you offline about that to sort of fine tune this answer, but we can be pretty fast.
Fantastic. That sounds good. So I appreciate that. Do you have any sort of closing statements either of you would like to make, or are you happy with just an adjournment?
I'm personally happy with an adjournment. I just want to say, thanks to Superintendent Bailey. Thank you to you, Chair. Thanks to all the counselors for, really digging into the language here and this very thoughtful sort of discussion and set of questions. And I appreciate sort of the policy and the legislation that you guys are wrestling with. And I just sort of want to underscore that from the law department's perspective, I just will underscore that, this ordinance looks very much like the ordinance that the Supreme Court upheld in Frisbee versus Schultz, with one giant difference. And Chair Arroyo, you focused on this a minute ago. The giant difference is that the targeted residential picketing is permissible for half of the day, right? It's only not permissible sort of when you are trying to sleep, when you're trying to get your kids ready for school. I mean, the real sort of times when protecting the tranquility and privacy of the home is even more important than perhaps at noon. It's a important governmental interest at any time during the day. The Supreme Court has recognized that repeatedly. But this ordinance is really only about when it's, targeted, it's focused on when it's, when that value is arguably even more heightened. So we will look at the specific language questions that we received today. We will get back to the committee as quickly as we can, and we really appreciate everybody's work here today in this working session.
Thank you. And just to be clear, to any counselors who are watching this or have staff watching this, all language edits, if you have language edits that we did not go over today, please email them to me, the chair, or to the committee itself so that we can then forward that over to Corporation Counsel. The edits that I saw today for the city legal department to explore, frankly, seem to be just on that one sentence about residential picketing. And then from my perspective, there was a second section of that we have more leeway with, frankly, which is the penalties and sort of defining subsequent offenses so that people understand how that works. And sort of, I believe specifically Councilor Lara's question about detailing what the appeal process for that would be. And I assume we could tailor that off of other laws that we've done and how that works.
Yeah, and just quickly on that, right? This is actually written the same way. Basically, all of our other laws are written.
Yeah,
but maybe what we will do is just make sure that every counselor has an opportunity to see Section 21D of Chapter 40, so that the sort of mechanism that, admittedly, if you didn't want to pay the fine, would require you to have to go over to the courthouse, what it looks like. So
fantastic. That I think that would be very helpful. So some very, I consider them, obviously in the case of law, they could be minor, could be major, but I think we've narrowed it down to sort of one paragraph that we might be able to rework, and then the penalties and what we may be able to do there, and just making sure that everybody sees that section that you just said. So with that, I'm going to adjourn. I want to thank all of my council colleagues for their time and their efforts today and their dedication to this. I want to thank Superintendent Bailey, especially for what was difficult, I believe, to you on call for most of this. And I want to thank Corporation Counsel and Mr. Arcangeli, right? Did I get it right?
You got it.
Yeah, perfect. Thank you. Fantastic. I hate getting people's last names wrong. So thank you all for your time and what you have done today. So thank you both. Well, all three, frankly. Thank you, everybody.
Thank you.
Thank you. Bye-bye. Thank you.
Thank you.